Before we go live here, sorry about that. To keep you all waiting, we're waiting for a quorum. So we've got people over in the house and house folks over here. So we're just waiting. I think we've got, do we have six? We've got six.
We have six.
All right, let's roll.
West is also in hearings.
Okay, excellent. All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 23rd. We have 11 bills on the docket, and we'll start off with Delegate Watson with House Bill 40. We'll then go to 210, 231, 368, 401, 446, 679, 764, 817, 885, and we'll wrap up with House Bill 322 with Delegate Lopez. So without further ado, Delegate Watson, welcome with House Bill 40.
Vice Chairman and members of the committee, thanks for the opportunity to provide testimony on House Bill 40, which deals with condominium law and seeks to protect the legal rights of condominium unit owners. This bill, as amended, passed unanimously out of the House Environmental and Transportation Committee by a vote of 25-0, and passed the House of Delegates unanimously on the third reader, 139-0. The bill is very simple. If passed, it will prevent a condominium board from waiving the legal rights of unit owners without their knowledge. This is the same bill that I introduced in 2020, but as amended, and it passed in the House, but it got caught up in the Senate due to the shortened session. The bill is offered to prevent a situation that happened in a 198 condominium development in Ocean City. In that situation, building deficiencies were discovered while the buildings were under warranty. The builder responded with a repair agreement to the Board of Directors, in which all current and future common element warranty rights were waived. And it also contained a non-disclosure provision which prevented the terms of the agreement from being disclosed to the unit owners. This ultimately resulted in an assessment on condominium unit owners that exceeded $50,000 per unit. I moved to reintroduce the bill this year after the Surfside condominium disaster in Miami, Florida. Not suggesting that this is the same situation as in Miami, but we don't know exactly what happened there. What I am suggesting is that a resolution to a structural deficiency which waives all future claims for a building should not be secretly agreed to without the unit owner's consent. This year's bill includes amendments offered in 2020 by the Community Associations Institute, the Maryland Legislative Action Committee, and those amendments specifies restrictions contained in the bill that apply to vendors and developers to allow for things such as personnel matters, which are routinely handled by boards without member involvement, and also specifies that the requirement extends the new provisions to lot owners, not just to unit owners. This session, additional amendments were added in order to disclose warranty settlement agreements to unit owners 21 days prior to execution, and to provide for the disclosure to potential unit buyers of an executed agreement. These amendments are the results of discussions with stakeholders, including Karen Strawn from the AG's office, representatives from the Community Associations Institute, and representatives from the Maryland Builders Industry Association. Thank you for the consideration of this bill. I'm happy to answer any questions.
Excellent. Thank you, Delegate Watson. Turning to the committee for questions. Seeing none, thank you very much.
Thank you.
Thank you for bringing the bill to us. Good to see you.
You too.
In person. There you go. All right. Well, that'll end the hearing for House Bill 40. We'll now move on to House Bill 210 with Delegate Grammer. Welcome.
Thank you, Mr. Chair, Mr. Vice Chair, and members of the committee. For the record, Delegate Robin Grammer here to present House Bill 210. In criminal cases, a person can be compelled to testify in a criminal trial. However, the spouse of a defendant cannot be compelled to testify as an adverse witness with limited exceptions. This is referred to as the spousal privilege. This issue explored in this bill dates back to a murder trial in 2011. In a conversation, a young man had confessed he had murdered Crystal Anderson in Southern Maryland. The woman to whom he confessed also saw him selling Anderson's possessions. That woman became the key witness in the prosecution of the murder trial in question. As the trial date came closer, the defendant made several calls from the detention center in which he was held with the purpose of pressuring the woman into a marriage so that she could not be compelled to testify, evoking his spousal privilege. Shortly thereafter, the defendant married the young woman on a conference call. The groom was in his detention center, the bride was on a break from work, and the pastor called in from New Jersey. This demonstrates a loophole in the spousal privilege which allows defendants, most of whom are male, to intimidate witnesses, most of whom are female, into fake marriages for the sole purpose of disqualifying that witness as their spouse as a witness. This is why the organizations supporting this bill are those who advocate against the abuse of women. The defendant in this case was subsequently charged with obstruction of justice and witness tampering. Those charges were appealed to the Court of Appeals, who overturned the convictions, essentially refusing to legislate from the bench. So the Court of Appeals has left this body to consider this question. House Bill 210 closes this loophole by specifying that you cannot invoke the spousal privilege if the person on trial and the spouse married after the date of the alleged crime. This will remove the incentive and the ability for defendants to use the tactic of pressuring witnesses, most of whom are women, into fake marriages for the purpose of eliminating their testimony. Last year, JPR moved House Bill 268, but we ran out of time. By passing this bill again this year, we strike at witness intimidation, we adjust the law to deter violence against women, and we close a loophole that allows violent offenders to evade justice. With that, I'd be happy to take questions, and I'd ask for a favorable on House Bill 210.
Yeah, I was just trying to remember because I thought we passed this bill. So can you, I looked, it said 2020 was introduced, and then the hearing got canceled here because was that a COVID thing?
Yes, the hearing was canceled due to COVID. Last year, it did pass from the committee. I'm fairly confident we ran out of time last year.
So we passed it out, and it was like a sine die thing. It just ran out of time on the floor.
I can't quote on the specifics, but it was a time issue, I recall.
All right, thanks.
Delegate Grammer, yeah, I think I remember this bill too from last year. We just didn't have enough time.
Okay.
And there was no opposition, is that correct?
There was no opposition.
Okay, thank you.
Thank you.
Well, that's not entirely correct. There was one frequent flyer that submitted some written testimony in opposition. All right. Yeah. Hey, thank you very much, Delegate Grammer.
Thank you, Mr. Chair.
Thanks a lot. Good to see you. All right, that'll conclude the hearing for House Bill 210. We'll now move on to Delegate Corman with House Bill 368. Welcome.
Thank you, Mr. Chairman, members of the committee. Mr. Chairman, let me just say I've never appeared before you before. As a former Montgomery County Young Democrat, it's a great honor to appear before you, Mr. Chairman. I come before you with House Bill 368, which involves penalty for lapses of security for grace period. This is really a sort of a constituent service issue. When you have a car in the state of Maryland, obviously you're supposed to be insured, and if you're not insured, you are fined. If you cancel your car insurance and then turn your plates in, however, there are some circumstances where the Motor Vehicle Administration is somewhat improperly fining you. They're issuing those fines once they find out the insurance has been lapsed, even though you might also be turning in your plates at the same time. So this is just to sort of close that loophole and make sure they're not improperly assessing fines when you've sold your car, the car's been scrapped, and so on. This just gives a little bit of a grace period, a stop and breathe moment before MVA starts issuing the fines. In reality, what happens is if they issue this fine and you say, well, hey, I sold my car and I turned my tags in and so on, they'll end up waiving the fine. I think a lot of people don't challenge the fines, however, so they're getting sort of fined unfairly by the Motor Vehicle Administration. So this is just to give a little bit of a pause and give our constituents a chance to not be improperly fined. We worked with the Motor Vehicle Administration on some of the specific language you'll see herein about when they find it appropriate to use this grace period. I'll also note they claim to have an informal 5-day grace period already. This would just make it a 10-day grace period with some specified circumstances. With that, as a House member, I thank you for letting us out of our cages, and I look forward to a favorable report.
Questions from the committee? Saying that, well, Delegate Corman, it's good to see you. I'm glad we're in different chambers because every time we've run in an election together, you've always beat me. So I'm glad we're at least in different districts. So
I hope that doesn't hurt the bill, but I am the last and only person, I think, to ever beat you in an election.
there you go. All right.
Thank you, Mr. Chairman.
From your mouth to God's ears. There you go. All right. All right. Thanks a lot. All right. With that, that'll end the hearing for House Bill 368, and we'll move on to House Bill 401. I don't see Delegate Holmes here. Oh, here he is. There he is. All right. Are you, do you need a second, or do you?
Nope.
Okay, excellent. Well, we'll start with House Bill 401. Delegate Holmes, good to see you.
Good afternoon. House Bill 401 is before you today. This is a very simple bill. This is a reserve study bill. And all that it does is that this is a Prince George's County bill, and it makes it consistent with the Montgomery County reserve study bill that they passed last year. Every 5 years, a reserve study has to be prepared. And what this bill says is the reserve study has to be updated. Updated is important because an initial reserve study costs a whole lot more than an updated reserve study. So every 5 years, you just do an update, and that's all this bill does.
Excellent, thank you. Yeah, looks good, all right. No questions from the committee, thank you very much. Good to see you again, 2 days
Thank
in a
you.
row. There you go. All right, with that, that'll end the hearing for House Bill 401. We'll now go on to Delegate Forbes with House Bill 446. Welcome.
Thank you. Good afternoon, Chair Smith, members of Judicial Proceedings. Thanks so much for the opportunity to present testimony in support of HB 446. For the record, I'm Delegate Kathy Forbes, and this is a Baltimore County bill. It increases the amount of funding the Baltimore County Historical Trust receives from the performance of courthouse marriage ceremonies from $15 to $25. Through some legislative action in the past, the Baltimore County Historical Trust and other nonprofit preservation groups across the state receive their funding through a Maryland family law statute. It requires a portion of the proceeds from courthouse marriage ceremonies to be directed to these preservation groups. This is their main source of funding. Across Maryland, with the exception of Cecil County, it costs $25 for a clerk of the court or a judge to perform a marriage ceremony. In Baltimore County, $10 of that goes to the general fund and $15 goes to our Baltimore County Historical Trust. This $15 rate was set in through statute in 2006. This bill has no state fiscal note and the support of our county administration. It passed the House delegation unanimously and the House floor unanimously, and I ask for a favorable report. Thank you very much.
Excellent, thank you. We have a question from Senator Huff and then Senator Watson, and then I've got a question for Hedelman and for Sidnor about a delegation letter, but.
Real simple. I have the exact same bill for Frederick County, so when we move this out, do me a favor, keep an eye on that Frederick County one coming over.
I testified right after Delegate Kerr.
Okay,
Who must
perfect.
have your cross-file.
Yeah.
In judiciary.
It's exactly the same. All right, thanks.
Yeah, I think we might have been asking the same question. My question was, does a favorable report from the county executive suffice for the delegation letter? Does not?
It does,
Okay.
we're pretty much good to go, but we should, I don't know when you all are meeting
So
next,
when
but-
it passed
Yeah.
out of the House, I sent it to Senator Klossmeyer and asked to get on their agenda, and I'll be in their meeting next Monday.
Excellent, all right, that'd be great.
Thank you.
And we'll get it moving as soon as we get the letter. All right, no further questions from committee. Thank you very much, good to see you in person.
Thank you.
Good
It's
see
nice to see you too.
Thanks very much. All right, with that, that'll conclude the hearing for House Bill 446. I do not see Delegate Stein unless he's in the antechamber. Delegate Valentino-Smith, are you testifying on behalf of that bill? Okay, well then we'll get you going. We'll go to House Bill 764 with Delegate Valentino-Smith. Welcome.
Thank you, Mr. Chairman, Senators. I have to tell you, it's my first time in 2 years over, so just to be here, thank you. It's wonderful. I bring you House Bill 764, Department of Human Services, Missing Individuals. Really, what this bill does is it requires DHS, who is sitting back there and okay with the bill, and the appropriate local Department of Social Services to submit a detailed report to law enforcement when a child in the state's care goes missing to ensure the child's safe return. The legislation passed the Judiciary Committee unanimously and the House unanimously, and the only reason it doesn't have a cross-file is because your dance cards fill so fast, and since I knew that this was likely to be non-controversial. The legislation clarifies the specifics that are needed in this reporting, and it helps and is needed so that outcomes aren't escalated, so that the police know everything they can. These are very seriously ill children if the state has custody of them. And so when they go missing, it's very important that law enforcement know immediately, and they know as much information as they can. They likely, I dare to say that abuse is sometimes the least of the things that have happened to these children. So we know the longer it goes after a child is reporting missing, the less likely it is that law enforcement will be able to locate the child. And we know that for every report that's done, every minute sooner it fares to the benefit of the child being located. So this bill puts the specifics in. You can read them. The most important is the idea that a photograph will now be provided and that the employee at DHS will be very clear to whoever is receiving at law enforcement. And I will tell you what happened this summer. I'm the vice chair of the DHS Budget and Appropriations, so I hear a lot about what goes on with foster and abused children. But we did have parents from Montgomery County whose child had to be taken custody of by the state for very unfortunate reasons. But nevertheless, the young man went missing several times from his placement. They tend to run away without 24/7 supervision. And each time he came in contact with the police had no idea that he was dangerous, nor that he was in custody of the state so that they could bring him back to where he could receive the treatment he needed. So with that, I'd ask for a favorable report.
Thank you very much. Questions from the committee? Seeing none. Thank you. Good to see you in
Thank you,
person.
Mr. Chairman.
Thank
It's very good to see
See
you.
you likewise. All right, with that, that'll conclude the hearing for House Bill 764. And Delegate Stein, are you prepared? I know you just got here, but are you? Okay, excellent. So we'll take you next with House Bill 679. Welcome.
Thank you, Mr. Chairman, Mr. Vice Chair, and committee members. This bill, House Bill 679, expands the mandatory licensing requirements for car dealership employees to include employees who sell finance, insurance, and warranty products. Now, under current law, MVA licenses car dealers and the salespeople who sell vehicles at dealerships. But there, as we all know, there are employees who interact with customers on financing, insurance, and other add-on products. So this bill would require that these salespeople meet the same licensing criteria as vehicle salespeople, such as getting fingerprinted and getting a background check. So in expanding the MVA licensing to this category of employees, this would help MVA address any complaints it receives from customers about these add-on financial products. Over half of all states require licensing of dealership finance employees, including Virginia, and the language in the bill is modeled after Virginia's statute. So I urge support, and in case there are any particular questions I can't answer, Travis Martz from the Maryland Auto Dealers Association is here to help.
All right, thank you very much. Questions from the committee? Seeing none?
Okay.
There you are.
Thank you
Cold
very
bench
much.
today. All right, here you go. Thank you
Great.
very much. All right, with that, that'll end the hearing for House Bill 679. And we can go on to see Delegate Shetty. Just got here. Do you need a moment, or are you good to go? All right, excellent. Delegate Shetty, you're up with House Bill 817.
Thank you. Hello again, friends. I feel like I was just here yesterday. Chair Smith, Vice Chair Wallstreicher, members of the esteemed Senate Judicial Proceedings Committee. For the record, I am Delegate Emily Shetty, here to provide testimony in support of House Bill 817. This is a bill that will prohibit a conviction for a violation of a protective order from merging with a conviction for certain other crimes when the underlying facts of the case are the same. This bill passed unanimously in both House Judiciary as well as on the House floor. So the idea for this bill was brought to us by several advocates who have provided written testimony to the committee, I assume. If not, I'm happy to send it. And it came as a result of the recent Court of Special Appeals decision in Morgan versus State. In this case, a defendant was found to have violated a protective order by committing a second-degree assault. I would direct you to take a look at the fiscal note, which provides a great summary of the case's findings and the court's open call to the legislature to address the rule of lenity. So, at the risk of sounding like a law professor, the rule of lenity requires that a court examine whether two charged offenses arose out of the same criminal conduct and whether the legislature intended to impose multiple punishments for the separate crimes. Absent specific guidance, if a court deems that two offenses have arisen out of the same criminal conduct, then the crimes merge for the purpose of sentencing. In these instances, the lower sentence of the two crimes is applied so as to not unfairly punish the defendant for legislative ambiguity. The General Assembly has identified several areas of criminal law that don't necessarily require sentences to merge, including child abuse and rape. In these instances where two crimes are being charged and convicted for, the sentences imposed are not always merged and can be served consecutively or concurrently. The court is granted discretion to determine what the appropriate sentence should be and is not constrained by the merger doctrine. So currently in Maryland, if a defendant has violated a protective order by physically assaulting an individual, the law is ambiguous and the sentences are therefore merged. A violation of a protective order carries a sentence of up to 90 days of incarceration for a first offense or up to 1 year for a second or subsequent offense, while a second-degree assault carries a penalty of up to 10 years incarceration, a fine of up to $2,500, or potentially higher depending on the victim or both. When the two are merged, a defendant convicted of both is only required to serve the lower sentence of 90 days to 1 year. What HB 817 would correct is it would allow courts to sentence an individual convicted of both to an appropriate sentence based on the unique facts of the case and the defendant's criminal history. This bill will effectively ensure that those who are under protective order are sentenced appropriately for committing an act of violence that is also a violation of the protective order. I respectfully request a favorable report, and I thank you for your consideration.
Thank you, Delegate Shetty. This bill looks like just a simple technical fix, right? Is that correct? And
That's
the court
correct.
still has discretion.
The court will still have discretion.
Okay, and there was no opposition to this?
No opposition at all.
Okay, thank you.
Seeing none, thank you very much. Thank you.
Thank you, Mr. Chair. Thank you.
All right, with that, that'll end the hearing for House Bill 817. We'll now move on to, I think, Senator Hester, are you going to come present for the Howard County delegation with House Bill 885?
Thank you very much. It's good to see you, Chair, members of the committee. Good to be on this side of the desk. For the record, Senator Katie Fry Hester, here to present local Howard County Bill HB 885, Howard County Sheriff's Salary. This bill sets the salary to that of a major on Step 6 of the Howard County Police Management Schedule and automates the increase so that the sheriff will no longer need to request raises from the legislature every year. It would increase the annual salary of our sheriff from $113,000 to $148,138, which is commensurate with the responsibilities of the office, including our wonderful new expanded courthouse. This increased salary will also enable us to attract qualified candidates in the future. The bill unanimously passed the delegation, and our delegation administrator has uploaded a letter of support for your file. For these reasons, I respectfully request a favorable report on HB 885.
Seeing no questions, thank you very much, Senator Hester. We were just talking about the, we've got a lot of the sheriff salary bills in this year, so wondering why that they fell under our purview, because it's a constitutional office. Got it. Okay, excellent. Thank you very much. All right, with that, that'll end the hearing for House Bill 885. We'll now go on to Delegate Lopez with House Bill 322. Welcome.
Good afternoon, everyone. Thank you, Mr. Chair. For the record, I'm Delegate Leslie Lopez, here to ask for your favorable report for HB 322. This bill clarifies Maryland's current law by automatically exempting $500 in an individual's bank account from collection by creditors. In layman's terms, this bill keeps creditors from taking your last $500. As they work to pay back their debt, Marylanders should not be subjected to so much wage garnishment that they cannot make garnishment that cannot make basic ends meet. Maryland's law protects $6,000 of an individual's property, including their vehicle, cash, and other valuables. However, this exemption is not automatic. The debtor must elect to take it. Many people facing debt collection are unaware of this, resulting in all or nearly all of their assets being seized to pay back the debt. HB 322 merely makes automatic a small fraction of this existing exception, shielding $500 in a debtor's bank account from collection. This amount, while a small number for the collectors, is absolutely crucial for these families. It can mean keeping the ability to pay for food, medication, rent, utilities, and other essential needs. With this bill enacted, Maryland's taxpayers will be protected from having to provide additional emergency funds for food, utilities, and additional household needs. And it also supports landlords, local businesses, and others by ensuring that the family has funds to use and circulate within their community. Many other states already have this automatic exemption, but for significantly more money. Delaware prohibits any garnishment of a bank account. Massachusetts protects up to $2,500. New York, $3,600, and Washington State protects $2,000 in a bank account. We opted for this smaller number because it built consensus from all the stakeholders, and the greater amount would undoubtedly be better for the sake of providing urgent relief. We all agreed upon this $500 amount. What this bill won't do is create additional difficulties for financial institutions to implement. Financial institutions in Maryland have already demonstrated that they are able to protect funds in 2020 in the response for COVID, and they did that with the stimulus funds. So in conclusion, HB 322 provides an automatic layer of financial protection that will give families more stability as they work to pay off their debt, and I would ask for a favorable report.
Excellent, thank you, Delegate. We have a question from Senator Castley.
A question. So if I have three accounts, one has 100,000, one has 200,000, and one has 500, each one then would be subject to the $500. You garnished all three of them. The one you couldn't garnish at all. And the other two you could take everything up to the $500 limit.
Sure. Well, it's only one set of $500, so it's one account, and that's usually the principal checking
So
account.
that's limited?
Yes. And we, because there is opposition, we do have an attorney who can speak specifically to your question if you want to ask her as well. But it's usually the primary checking account.
So Senator, you know, we did this, like, we dealt with this a couple years ago, but there's like this $6,000 wild card that you basically, it's assets or what's in your bank account.
Mm-hmm.
So this just says that of that 6,500 shall be cash money in your account.
Okay,
Yeah. So no more than that, which is already in the law.
thanks.
Yeah. Senator Watson. My question, so I know that most of the institutions there's pretty much, I think you've done a great job bringing consensus and working things out. One, I just want to make sure we have an opportunity to address it during the hearing so that we go, during our voting session, we have the information, is that the institutions, how do they know whether you fenced off, whether the 500 that they're supposed to fence off has already been fenced off as part of that 6,000? I think that's the testimony that they've submitted, is that they and I see Ms. Hennon over there if she wants to step forward, but that's the one lingering thing that I'd like to have information on before we head into voting. And Ms. Hennon can she stood up, but I defer to the sponsor of the bill if she's there, if she wanted to answer,
Yeah.
but I'll defer to the sponsor of the bill.
My pleasure. Chair Smith, members of the committee, thank you so much for being here. I'm Amy Hennon. I'm the Director of Advocacy and Financial Stabilization at the Maryland Volunteer Lawyers Service. My organization connects low-income folks with volunteer attorneys in their communities throughout the state, and about 1/3 of the cases that we see every year are consumer-related. I have personally assisted a number of clients with doing the exemption that exists now, where you fill out what's called it's a DCCV 36, the District Court Civil Form 36, and you mark the 6th box that says, I'd like to exempt the amount allowed by law, and that's the $6,000 that they can protect in their checking account. With regard to whether or not the $500 would be exempted if they've already exempted it. This is something that the creditor can say when they are filing the creditor's going to know if an exemption has already taken place, because they filed a previous bank garnishment. They're going to have the response that's set from the bank that says $500 is exempt. The creditor, if they filed to go after a different bank account, they would then have the ability to say the $500 or the $6,000 wild card exemption has already taken place. And this is actually an issue that exists already with the wild card and is not being expanded with the just solo protection of this $500, because it already is the case that if a debtor elects to protect the $6,000 in their account, and then the creditor goes to file against another another account that might have $6,000 in it, they're not entitled to protect that additional $6,000, but the bank doesn't necessarily know that at a different bank they've already had the $6,000 protected, and thus the creditor needs to say in their filing they have already obtained the wild card exemption and they're not entitled to protect any further amounts.
right,
I hope
additional
that
que-
adequately answers the question.
It does, but, so I do want to, with limited testimony here, balance out of balance. If Mr. Enton, I know if you want to respond, I want to make sure you have an opportunity to weigh in, but that's it. But otherwise, let's go with Senator Castley.
I mean, typically, a creditor is going to say, oh, I see you have 4 accounts, and they'll issue garnishments against all 4 accounts at the same time. They're not going to wait and say, well, I'll do those in series. I'm going to hit all of them right away because you're going to be moving money around. You'll be taking it out. So I'm going to hit them all at the same time. And now, how do I know that? How does each bank know that we've claimed which ones the exemption's been claimed on when the bank responds? They're going to all come back and say, well, there's a 6,000 exemption, right?
So the bank would not come back and say there's a $6,000 exemption. The person has to file and exempt that amount.
Okay. After the bank accounts have already been frozen by the.
After the account has been frozen, the debtor has to file and request that the exemption take place.
Okay.
So in my experience, it's a mix of whether they would all be filed against at once, or in fact, if they would be filed in some sort of succession. And actually, the succession is much more common, simply because the creditor will often know about one bank account and then perhaps do another search and find another bank account. And so they would potentially file in some sort of succession to go after funds that have been moved.
But they ask for the exception after you put the garnishment on the account.
Yes.
Then the debtor responds and says, okay, I claim 500 or 6,000, whatever it is, and then the creditor comes back and can say, oh, no, wait, you did that 2 weeks ago for the other account, right?
Yes.
Okay, thank you.
Alternatively would be if they were going to file a new exemption, or sorry, a new bank garnishment and say on it, the $6,000 exemption has already been claimed.
All right, no further questions from the committee? All right, thank you, Delegate Lopez, thank you, Amy, Ms. Hennon. And then, so now, out of fairness, we'll have Mr. Enton. Bob, if you want to come on up and provide your testimony.
Thank you, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. You have our written testimony, which points out the problems that the banking industry will have administering this legislation. The bank has absolutely no way of knowing whatsoever what other exemptions the judgment debtor may have claimed. All we know is that the bank account was attached. So today, we file an answer. The judgment debtor fills out a form to contest it, and a court can decide how much gets attached. It is totally, completely unprecedented under Maryland law. There are no automatic exemptions to date, and we're just not equipped to deal with it. If we don't know whether or not the exemption takes the judgment debtor over the $6,000, then we will be exempting money that under Maryland law shouldn't be exempted, and is not entitled to be exempted. I would also say to you that in addition to the lack of precedence for this and the operational issues that every bank in the state will have. Imagine if you've got 1 million bank accounts in the state of Maryland, you have to deal with garnishments every day. You do it in an automated fashion, and now you're going to have to completely change your system for dealing with those garnishments. To me, a $500 exemption for everybody is not the solution to trying to make sure that low-income people have adequate funds to meet their needs. We do that through the budget. We do it through programs. To me, the key is to make sure that judgment debtors know what exemptions they have under current law and how to claim them, because they can claim up to $6,000 in exemptions whenever their bank account is garnished. And if you look at the forms, and I've had this discussion with Judge Morrissey, the Chief Judge of the District Court, the forms for the judgment debtor to fill out and the forms they get are not clear at all. They don't advise the judgment debtor that he can claim exemptions. They don't advise the judgment debtor how to claim them, and they don't advise the judgment debtor to list the exemptions that they've taken to date. So I know that there were meetings during the interim about this. We're the ones that have to administer this program. We were never included in any conversations or any meetings, and to my knowledge, neither was the judicial branch. I would ask the committee to give the bill an unfavorable report. Let us work on this during the interim with the judicial branch, with the consumer advocates, and come up with a program that's workable. But we just don't think that's this program. I did share my testimony with the sponsor before the hearing. I've thought about amendments. The Senator drafted some amendments even. But the more we've gotten into this, the more we feel like it's really needs more work, and this is not a proper year with the proper amount of information on how to do this. And finally, in closing, I would say that if I'm a judgment creditor, what have I done wrong? You know, I've extended goods, I've extended services, I've extended money to someone, and now, regardless of that person's wealth, regardless of anything else, I'm going to take a $500 hit if I can find an account to garnish. And I used to do collection work. Most of the time, if you're a creditor, maybe, and we're getting checks in the mail, you know there's a bank account. That account, once that garnishment hits, that account gets closed. Nobody's going to keep an account open that's been garnished. And then where do you go to try to find out where you can recover on your judgment? So I just think that this bill needs more work. I'm not opposed to granting the exemption, but it needs a lot more work to figure out how to do it. Thank you.
Thank you very much. According to our records, you were just presenting oral testimony, so we don't have anything.
I'm hard time hearing you, sir.
We just have oral testimony, so we don't have anything in writing. But I noticed that before judiciary, you were noted as favorable with amendments.
Well,
and you had noted that you had some amendments, but I guess you thought that now it needs a lot more work, so you're testifying unfavorable here. So what I was wondering is, did you have a copy of what those amendments were going to be?
Well, I told Delegate Lopez I'd be happy to meet with her and talk about amendments.
No, I mean for us.
I'm sorry?
Do you have amendments? Do you have anything you want to share with us? Do you have amendments you want to share with us?
Yes, to see if we can work something out with the sponsor on the bill. Let me say that the instructions on the General Assembly website say if you want to testify in the Judicial Proceedings Committee, you have to be opposed. You can't come in favorable with amendments. So we are opposed. But I just am troubled by how this bill will be implemented and really whether it's the best solution or not. The amount doesn't bother me, but it's how it's going to be administered that bothers me. And the other part that bothers me is that I think most judgment debtors don't have a clue that they're entitled to claim a $6,000 exemption. If they knew they could claim a $6,000 exemption, why would we need the $500 automatic exemption?
But is there anything in writing that you can share with this committee? I mean, if we wanted to work,
It's not working well today.
if we wanted to work on this bill, is there anything in writing that you'd be willing to share with this committee?
Well, I'd like to talk to the sponsor about it and maybe sit down with the consumer advocates and see if something could be worked out, and I would certainly share it with the committee and with you.
Thank you.
Two things I'd like to ask you, Mr. Anton. First, the judiciary has not been shy about telling us what they think about bills this session, and I don't see any testimony in here from the judiciary. So that's sort of point one I would love your comment on.
Can I respond to that? Because I've had a number of conversations with Judge Morrissey. This won't change, this doesn't impact them at all.
Okay.
Not at all. The only one it impacts from a procedural point of view in a negative way is the holder of the funds, and that's for the reasons that I stated.
Okay. So the second question is, there are certainly a lot of banks in Maryland that also have banks in Delaware and Massachusetts and California and New York, and the sponsor listed a number of other states where they're able to provide self-executing exemptions, and somehow they figured out a system in those states where they're allowed. So why is it that they wouldn't be able to do it in Maryland if they're already doing it in other places?
Well, I would say to you that, as, you know, people come in front of the General Assembly all the time and say, this is the law, and, you know, 6 other states, this is the law, in Virginia and Delaware and Pennsylvania, all our surrounding states. But every law is different. And Maryland's garnishment law is significantly different than the law in other states. We are one of the few states in the country which doesn't have what we call a snapshot garnishment. That is, the garnishment hits, and it only applies to whatever money is in the account at that time. It's a snapshot. And what makes Maryland's garnishment law so difficult for my clients is that the garnishment continues as they go through the process until the order is given and the case is closed. So for every new dollar that goes into the account, you've got to look at that deposit, you've got to file an amended response in the court. So we are a much, much different state. Our whole process is much more convoluted in many ways than the garnishment process in other states. I'd be happy to furnish you with copies of those other statutes so you could see the difference, but like everything else, well, I know there are some states that do have automatic exemptions. You have to look at the whole statute and at the rules of procedure to see just how they work. Under our statute, under our rules, this bill just on its own is really problematic.
Well, I think it would be helpful for the committee, because there are at least 5 other states that we're aware of that do this. So it would be helpful to see kind of how we are similar and
I'd be happy to
dissimilar.
furnish that to the committee.
Thank you.
Do you have any response to what the advocates have said? As I understand how this works is, you're entitled to a $6,000 exemption. If I garnish your account, it has 500, the bank's automatically going to exempt 500, and they'll notify me, the creditor, that they just exempted 500. Then I respond and say, wait, they already exempted 6,000 already, so that's not a valid exemption, at which point they can then respond or not, and then I guess the court would then order the forfeiture of that 500. Isn't that how this works?
Now, I would tell you how I think you highlight the problem. The only person who knows whether or not the judgment debtor has claimed $6,000 in exemptions is the judgment debtor.
Well, the creditor would know too.
No, the creditor's not going to know. The creditor doesn't know. It's not $6,000 per creditor. It's $6,000, period, in exemptions. That's how it works. And the only person who knows whether exemptions have been claimed previously is the judgment debtor, him or herself. Creditor A doesn't know anything about prior attachments or garnishments by other creditors. And that's one of the problems with the bill. No one knows but the judgment debtor what exemptions have been claimed. No one. So you kind of make the cap, meaningless in that fashion.
Thank you.
I used to do this as a young lawyer, believe me.
I have a follow-up question to that. So then I would expect that creditors would be opposed to this bill. Is that true?
I'm sorry?
Based on your back and forth, then I would expect the creditors to be opposed to this bill. And my understanding is that they're not. Is that true?
I will tell you why they're not. Because last year, you never saw last year's bill. Last year's bill came in at $2,600. And trust me, the creditors, the collection bar, there's no Maryland Association of Creditors, but there is a Maryland, D.C. Collection Attorneys Trade Association.
Right, I know.
They came in last year in the House opposed to the bill. It was Delegate Queen's bill. She withdrew it so that it could be worked on during the interim and come back with something. Look, they came back with $500. So frankly, I guess for the creditors, and it's mostly not the creditors, it's the collection bar. So if you're getting 20% of whatever you collect, and now there's a $500 exemption, and maybe you'll get, what, $100 less in fees, it wasn't apparently worth the battle for them. I'm not addressing this as a creditor. I'm addressing it as the person that has to handle the garnishment and has to comply with the rest of the statute that's on the books. I don't have a problem with the $500 from a creditor, and my clients are all creditors, but that's not their concern.
All right, additional questions from the committee? Seeing none, thank you very much, Mr. Renton.
Thank you for your time.
Thanks.
Appreciate it.
And with that, that will conclude the hearing for House Bill 322. Thank you, Delegate Lopez. Good to see you in JPR. All right. We have one more bill left, and that is from the Montgomery County House Delegation. That's House Bill 231, and we'll have Vice Chair Walstreicher present it.
Thank you, Mr. Chairman, members of the committee. House Bill 231 is a local delegation bill. It passed in both the House and Senate delegations unanimously. What it does is it takes Montgomery County's automatic traffic camera enforcement, automated traffic camera enforcement, and shifts it to the Montgomery County Department of Transportation. I support this bill 100%. And without reservation. Last year, I similarly supported the bill, but there was a hiccup at the end related to how this bill treats municipalities, of which I have many in my legislative district, as does the chairman, has one big one. That hiccup has been resolved. I urge a favorable report on this local bill.
Thank you, Mr. Chair. Did the Montgomery County Senate delegation support this bill?
It did. The Montgomery County Senate delegation voted upon this bill and did so unanimously.
Good, thank you.
All right, seeing no further questions, thank you, Mr. Vice Chair.
Thank you, Mr. Chairman.
All right, and with that, that will conclude our hearings for the day. I had previously said that we were going to vote today, but we are not going to vote today. We'll probably vote tomorrow, quick voting session tomorrow. Members of the committee will be given an opportunity to just review the materials before we vote well in advance. So we'll have an opportunity to discuss and deliberate on those before we vote. So with that, that's the end of our day. See you all tomorrow.